Hi there, it's Heather from BMO Healthcare. Why do I support pharmacy in Phlux? Because they support pharmacists. Your pharmacist helps you find over-the-counter medications, answers your COVID questions, provides essential services without the same recognition as other healthcare providers, partners with your doctor to change or adjust your medications, delivers information and classes on diabetes, heart health, high blood pressure, and more, and gives flu shots while you take 5 minutes out of your shopping. So why do I support pharmacy in Phlux? Because they support pharmacists. And everybody knows pharmacists are faster than a speeding COVID droplet, more powerful than a raging flu, able to leap tall counters to give a naloxone shot during the opioid crisis. BC, because pharmacists, you are healthcare heroes, a vital part of the health and well-being of this great nation. Stay tuned for more Pharmacy in Phlux episodes with key people talking about relevant industry information. And like Pharmacy in Phlux, BMO is here to help. Ask me about BMO for pharmacists. I'm available at 604-354-4989 or email me at heather.yuzik@bmo.com.
Hello, everybody, and welcome to this episode of Pharmacy in Phlux. We're glad you could join us again. We've got two guests with us today. I will introduce them to you. First, we have Heather Yuzik. Heather is the Director of Business Development for Healthcare at BMO and also the Regional Market Leader for Healthcare. Heather's been with BMO for 10 years, providing solutions to the healthcare industry in BC. She's been a visible presence in the pharmacy community for many years through webinars, social media, guest lecturing at UBC and the like, and she's well known in healthcare industry circles. Our other guest today is Patrick Madaisky. Pat graduated from UBC Law School in 1988, and for the first 11 years of his career, he practiced in a large Vancouver law firm. And he subsequently set up a smaller boutique business law firm. Well, first he practiced at one, and in 2000 he established his own law firm called Madaisky Company Business Lawyers. And since 2000, in the last 20 years, the firm's grown since then, which was initially just Patrick and his wife Dolores, to 14 people today, including 5 lawyers, and they're based in Langley out in the Fraser Valley. The firm has over the years developed an expertise working with healthcare professionals, assisting them with all sorts of their business-related legal needs, including incorporation, commercial leasing, buying and selling of businesses, corporate reorganizations, and general contract matters in real estate. So Heather and Pat, thank you for joining us today, and we're glad to have you on board.
Thank you for having us.
Thanks for having us.
I'd also like to note to our audience that this episode is being sponsored by BMO, and Heather, we thank you for the support and sponsorship from BMO for this episode of Pharmacy in Phlux. Now, we've got a lot of topics that we want to cover from a business perspective and a legal perspective today. And I'm going to turn it over to my colleague and co-host of the program, Phil Hauser, to launch us with the first question to Pat, and then we'll take it from there and jump around and cover as much as we can in the course of this episode. So, Phil, go ahead.
Thanks, Derek. So, Pat, you know, this is something that Derek and I run into constantly is we get approached by a pharmacy professional. Sometimes it's a seller, sometimes it's a buyer, and they're exchanging proprietary information, and there's no non-disclosure in place. It happens more frequently than we'd like to see. And so maybe you could just speak to the importance of a non-disclosure agreement, obviously from the seller's perspective, but also for the buyer who's engaging somebody for the first time.
Well, certainly, I think it is very important, Phil. Generally, I would say it is more important from a seller's perspective because for the most part, if they're selling, they're the one who are going to be disclosing their proprietary information, whether it has to do with their prescription counts, financial statements, their employee situation, their lease. All of that is generally considered confidential. So I think it's important that before things get too involved, that a seller always have a buyer sign one. And these things don't have to be these daunting legal documents. It can be simple 1 page or 1.5 pages that are easy to understand if it's drafted properly and will do the job. From a buyer's perspective, it's something that it depends what they're going to be disclosing. If they want to just keep the whole nature that even discussions are having or taking place confidential, it sometimes makes sense. What I see on the, we do a lot of work with dentists and a lot of consolidation going on with dental offices. In those cases, the big corporate purchasers always have these very complex and convoluted non-disclosures that they want the buyers to sign, which often have little surprises in there that sellers don't realize unless they get a lawyer to look at it. So as you mentioned, in a perfect world, it's nice. They should be signed. Like you said, often if people are just starting and not getting advice or guidance, they'll go down the path without it. But certainly something that's highly recommended, particularly for the seller, can be easy to put in place so that it can prevent some potential problems down the road with someone using some information that they otherwise shouldn't be.
Good information there, Pat. Thank you. Let me jump to another thing that we quite often sort of run into with our clients, and that is, when is it time for folks to turn over a copy of their letter of intent to their lawyer to start understanding what's going on with the deal and perhaps even drafting the purchase agreement. I mean, one of the things that we run into is the question often is should the lawyer see this before any of the conditions precedent are satisfied, or is it better to wait until most of those conditions have been satisfied?
That's a very easy answer. The sooner that someone can get a letter of intent in front of a lawyer, whether they're buying or selling, the better. A lot of people are under the misconception that, well, I don't want to get a lawyer involved because I don't want to start incurring fees until we know we've got a deal. But more often than not, if they're signing things, whether from buyer or seller, they're going to be leaving some things on the table that they really shouldn't be, or they might find themselves agreeing to terms that they shouldn't be, even though letters of intent are generally not legally binding. But once the parties have put their thoughts on, it's sometimes hard to backtrack from that. And just an example, I've spent the last 3 weeks negotiating for a client who signed a letter of intent on a deal without seeing me first. And then when I actually sat down and tried to explain to him, hey, do you understand this is what you agreed to here? He didn't quite grasp what he was signing on. So I've tried to backtrack. I managed to do a pretty good job so far of kind of getting him back on the right footing. But clearly, the sooner they can get someone involved, in fact, the minute I would say someone is thinking of buying or selling their pharmacy, they should just let their lawyer know and say, hey, just, this is what I'm thinking, and I might be leaning on you for some guidance as we go through the process. But it's something that more value can be added. The sooner that we can get involved, the better. I'm sure Heather can probably comment on that as well in terms of deals she's seen maybe come across her desk, and if the lawyers get in a little bit too late, then sometimes there could be some things that we have to try to backtrack out of it. But clearly, the sooner the better. If you think you're saving dollars, you're not, and it's just short-sighted in my view to take that approach.
Heather, did you want to add something to that?
I would just obviously fully agree with Pat. The sooner the better in sharing information with your banker and with your lawyer. And also I find in banking, pushing out, and it would be the same for Pat, pushing out the dates is always more comfortable for everybody involved. It gives us time to add value, gives us time to do our jobs properly.
Yeah, and one thing I just want to point on, there's a lot of concepts that sometimes that people are agreeing to that they don't fully understand the implications of. For example, a number of deals will have earn-out provisions, but to someone selling, and if a buyer is saying, listen, well, we'll give you earn-out based on production, in their mind, it might be a simple concept, but those types of things can be very, very complicated. Is it an all or none earn-out? If you are $1 short, do you lose all your earn-out, or can you stage it some way? So there's things that the lawyer, especially a lawyer with experience, can do, not only from a legal perspective, but just to help you negotiate a better deal, whether you're buying or selling. And you have to be careful too, depending on the the level of what's what I'm looking for, expertise or experience of the party you're dealing with, sometimes you have to really be on your toes. And if you're new to it or it's your first deal you're doing, I can guarantee you there's things that you may not understand. So a lawyer can certainly help, again, not only on the legal front, but just looking at the business terms and trying to get you the best deal possible.
Pat, you hit on something important there when you mentioned an earnout provision. I just wonder if you could quickly summarize what an earnout provision is for our audience.
Sure. An earnout is something where a buyer might say, I think your business is worth $1 million. And the seller says, well, I think it's worth $1.2 million. So the buyer will say, okay, I will pay you $1 million on closing. And if in the first year or whatever the period is after closing, the cash flow is there that you think it can generate and that we think it would need it to be worth 1.2 million, we'll pay you the extra $200,000. So it means that the seller is not getting everything they want up front, but if the business functions as they think it should, and if the buyers can make it work, then they might get extra dollars. So basically, it's the earnout is when the seller has an opportunity to earn more money than they get on the closing date based on the performance of the business. And sometimes that's tied to the seller agreeing to stay on for a couple of years and run the business or work in the pharmacy. So but they can get very, very complicated very quickly if the issues aren't addressed up front.
Yeah, that's great. We run into those kind of issues all the time, and I know oftentimes our clients don't necessarily understand the implications and what's required to actually earn or get all of the potential earnout. And like you said, are you going to have a chance to earn some of it, or is it an all or none kind of a thing? And there's all those sort of implications. You hit on another topic in your previous answer as well that I wanted to come back to, and I think it's just around the concept that oftentimes people are hesitant to get a lawyer or other professional involved sometimes early on because they think they're saving money by not incurring fees. And I think our message to them always has been, and obviously I think it's the message you were trying to deliver as well, is you're actually probably not saving money. And in fact, you're probably end up going to cost yourself more money, or may in the end, if you don't get the right professionals involved early enough in the process because of the things going off the rails or committing to things that really aren't necessary or that you can't back out of after. And in fact, people are quite often going to actually save money by getting the right professionals involved early on in the process.
Yeah, and one thing I'll touch on that point, and Phil has worked with our firm for many years, and this is not how most lawyers work who keep track of time and charge hourly rate. But in our office, and I've done this for 20 years, and one reason I went on my own and started my own firm, I was tired of keeping timesheets and recording time. I tell my clients, listen, call me. I'll work with you. If for some reason the deal falls apart, I'm not going to send you a bill for the time I've put into it because my hope is that they see I can do a good job. And when they go to buy the next one or the next time another buyer comes, they'll call me. And at the end of the day, hopefully we'll get a deal done at some point. And usually in our office, we will, once we get a handle on what the deal's involved, we'll give them a very accurate quote up front, what it will cost them to get from A to Z. And so they can budget and there's no surprises. So it's a bit of a different approach, but it's worked well for us. But that's why, at least in our office, I tell my people, hey, call me. Again, if we spend 3-4 hours or 6 hours going back and forth and it falls apart, then I say, well, don't worry, but keep me in mind for the next deal. Again, but I can't speak. There might be a lot of people out there watching. Their lawyers don't work that way, but again, it's just a different approach we have.
Great.
So, Pat, you mentioned earlier that most letters of intent are non-binding. What's the difference, if any, between a exclusivity and standstill clause and a no-shop clause? Those are sort of common road bumps that we see often in letters of intent.
Yeah, those are what an exclusivity clause is. The buyer is going to want to know that once you come to the basic terms in the letter of intent and parties, price, closing date, are we selling assets or shares, what are their conditions precedent? And once the parties sign on that letter of intent, which, Phil, as you know, they could be anywhere from 1 page to 15 pages, depending on how involved the parties want to get. But at that point, when the buyer is going to start incurring some additional expenses and due diligence, whether it's accounting, legal, getting their lawyers involved, reviewing leases and contracts and things, they want to make sure that the buyer or the seller is not out negotiating or dealing with other parties, quite simply. Otherwise, the buyer can put in all kinds of time and expense and effort, and the seller 3 weeks later can say, this letter of intent we signed, I think I got a better deal, so thanks, but no thanks. So very often what you find in these letters of intent, there'll be a clause that says, this letter of intent is not legally binding except for the provisions that deal with exclusivity. And usually as a seller, you want to make sure you don't tie your hands too much. There has to be a time limit on that. Obviously, usually it's the due diligence period of 2, 3, 4, or 5 weeks that the seller says, okay, while we're going through this, the parties agree to act in good faith. Again, some buyers might try to, you mentioned sort of a standstill clause. I've seen in a lot of deals that I do where the buyers, especially the corporate and the bigger entities, will say, not only will you exclusively deal with us, but if this deal falls apart, you can't negotiate with anybody else for a period of 3 or 6 months. So they try to tie you up, and it's all done to try to lock you in and force the seller to do a deal with them. Those kinds of clauses I don't really like, and I don't really think they're fair, from a seller's perspective. And if I'm acting for a buyer, it's usually not something we would insist on. Just get a simple exclusivity. Once we've got a letter of intent, let's negotiate in good faith to try to conclude this. If it doesn't work out, we each go our separate ways. But you raise a good point in that you have to be careful. And even documents like that, I've seen some clients sign one, they don't want to send it to their lawyer, and all of a sudden I have a look at it and I go, well, do you know what you agreed to here? You can't talk to anyone else for 3 months even after this falls apart. So what might look like simple early on documents in a process, they're all significant, and I think it's important that you get proper advice before you sign. It's not something that takes a long time. It's something you can flip to your lawyer and they can look at it in 5 or 10 minutes and say, yeah, this is fine, or hey, let's strike this out, and then you move on. So
great.
That's great. Yeah, good information there, Pat. I'm going to jump to a different topic here now, and maybe Heather, you might want to weigh in on this one as well after Pat, and that's the whole issue of assets versus shares. You mentioned that, Pat, and we kind of run into the situation in the pharmacy world, at least, more than anything, whereby buyers really only want to buy assets for the most part, and I'm generalizing here, and sellers quite often, depending on how their business has been structured, may want to sell shares for tax purposes in terms of potentially being able to take advantage of lifetime capital gains exemptions or things like that. The issue quite often, and in pharmacy worlds in particular, one of the reasons for buyers not wanting to buy shares is the potential for liability to go along with that. There's a lot of liability in the pharmacy world for pharmacies to undergo audits on previous or past business by pharmacare or private payers. And so not purchasing shares means you're not taking on that potential liability, although that I'm assuming can be addressed in a purchase agreement. So I guess just maybe expand a little bit from your perspective in the legal world, assets versus shares, what does that look like? Is there an advantage to one over the other? And then maybe Heather, from the banking world, does the bank care whether a purchaser who's looking for money is purchasing shares or assets?
Yeah, that's a good question. And here's what I would say. A lot depends on the leverage of the parties. If a seller wants to sell shares and they've got a good business, they're going to find someone to sell shares. You mentioned all the risk. From a buyer's perspective, those risks can be mitigated by doing due diligence. If there's concerns of audits, often you will negotiate some kind of a holdback for a period of time in case anything comes out of the woodwork. In terms of looking at the financial statements, the accountants can usually do a pretty good job of looking at 3 years tax returns and financial statements to make an assessment of what is the risk of audit here. You do usually get representations and warranties on any deal from the seller if they're selling shares that effectively say, if anything comes up out of the woodwork, I'm going to hold you accountable for that. Yes, if the seller's gone or left the country, or you have to sue them to recoup on that, does that help you? Maybe not. But practically, in my 20 years of dealing with healthcare professionals and buying, selling these, the savings to a seller of selling shares and being able to effectively claim for each individual $850,000 tax-free, as opposed to maybe doing an asset sale where they might only net at the end of the day after all taxes $400,000 or $450,000. It's a very compelling reasons, and usually it can be worked out, whether it's through holdbacks and agreements and indemnities, that that you're going to be able to get a deal done on a share basis. I can probably only think of one or two instances in my career where the seller was adamant on shares and the buyer was adamant on assets, and everything else made sense, but they couldn't come to terms on that, so they decided not to do the deal. And if I think back in the 1,500 or 2,000 deals we've done in our office over the years, I'd say 80% are share deals. If I had to say how many of those can I think where an issue came up after the fact, a liability, I would say maybe 3 or 4 times. In that case, the parties, I think in most of them, used to work it out. And I think in one of those, there was some kind of outright fraud involved, which is always difficult to protect yourself in any case. So it's something that could be addressed right off the bat. If someone's selling, they absolutely have to let their accountant know, not a week in advance, at least 2, 3, 4 years in advance, that they're thinking of selling their business, because in order to qualify for that capital gains exemption, certain tests have to be met. And those are things that you might have to start setting up in advance. So if anyone who's watching out there is thinking of selling, let your accountant know, even if it's not 5 years down the road. Say, hey, accountant, can you let me know, am I positioned when the time comes for me to sell, that I can sell the shares and claim my capital gains exemption? Because really, if you think about it, there's only 2 times in your life where you can earn income and make money and not pay tax. One's when you sell your principal residence. Hopefully that will continue. And one is when you sell the shares of a qualified small business, which most pharmacies will qualify for. So it is a concern, but it's usually one that is driven by sort of how the leverage of the parties, and it's really compelling on a seller that they're going to try to push for shares, but the savings are just too much. And usually from a buyer's perspective, there's steps we can take to mitigate. You can't eliminate it, but you can certainly mitigate that risk. It's a bit of a cost-benefit analysis at the end of the day.
Yeah, great. Heather, from the bank's perspective, does it matter to the bank if the purchaser who's coming to apply for a loan is purchasing shares or assets?
Well, of course, Derek, we've seen both share purchases and asset purchases, and we would just adjust our security accordingly. Oftentimes, the bank will secure their own lawyer as well, and just depending on the transaction, to ensure that the bank is also represented and protected. So all those parties work together, and the bank will accommodate the whatever the decision is made as to the type of purchase, and then tailor make the transaction accordingly.
Great, thank you.
Great.
So Phil, where do you want to go now?
Yeah, I was just want to back up a bit, Pat, to the LOI, and there's always a provision in there for employees where the purchaser has the right to not hire the employees of this particular business on closing, and so they have the choice to accept or reject the employees. And then there comes in the whole conversation about severance and how that plays out. You want to talk about that a bit, and from your experience, and what's the best way to approach that?
Sure. The best way to approach that, to be preemptive, if you're running a pharmacy and you have employees, have them sign some simple employment contracts. It's very, very easy to do when you first hire them. If you want a template, anyone can email me. I'll send them a simple little 2-page template that they can set up for their pharmacy and fill in the blanks as employees come in the door. And really what that does, the main thing is it's going to limit the severance liability if an employee has to be let go in the future without cause. So I could talk for an hour on just employees, and I'm not going to, but it is an issue that comes up in the purchase and sale of any business, whether it's the pharmacy. And the key thing from a buyer's perspective is they don't really want to be caught up inheriting, if there's a 10-year employee, a potential 10-year severance obligation. If there's no written contract, they potentially could be that employee could be entitled to 6 to 10 months of notice or pay in lieu of notice if they're going to be let go. That's why I referred back. If you can have them sign contract, you can limit them to the employment standards minimum, which is a maximum of 8 weeks. But it's something that is negotiated, and part of my job as a lawyer too, and experience, if I have clients come in and the first thing they say is they want to buy a pharmacy or what have you, Pat, I'm worried about the staff. I say, listen, these staff are an important part of the business. I try to approach it from a different view and view them as an asset, as not a liability. Sure, we can build in some provisions, and what's commonly done sometimes is a buyer and seller will agree, hey, you take on all the employees. If you let them go within 90 days, then I'll split the severance pay with you. After 90 days, you're on the hook for all the severance pay. That people have this mistaken notion that you can just fire and rehire. The old person fires them, the new person rehires. Doesn't work that way. There's provisions in the Employment Standards Act that when you have a sale of a business, especially business assets, that the employment is deemed to be continuous. So you can't get out of the vacation entitlement after 5 years and roll everyone back for obvious reasons. Otherwise, people, if they could do that, they would just keep flipping from one business to another or related companies to try to get out of those protections that those employees have. So yes, employees are often one of the 5 or 6 big issues that are subject to negotiation. If it's nothing but short-term employees, Phil, it's not an issue. But if there's 10, 15, 20, 25-year employees, it could potentially be subject to negotiation, because when you look at the letter of intent, really you're just trying to get the parties. Is it assets, shares? What is the price? When are we closing? What are the conditions? Often there'll be a term about what role will the seller stay on or play after the deal closes. And employees is something that's in that heading of those 6 or 7 topics. How are we going to deal with those? And again, if a seller has a smoking business and they say, listen, I'm only selling this if a buyer agrees to take my employees on as is, where is, and the buyer wants it, then guess what? That's how the deal is going to be structured. And oftentimes that's not a bad thing, because again, the employees, as we all know, are integral to it. And usually part of the due diligence might be for the purchaser to have the opportunity to sit down and well, in the old days, you'd have lunch with everyone and say, hey, I'm thinking of buying this business. Does anyone have any concerns? And a lot of time, the job of the buyer is to satisfy themselves that those employees are in fact going to stay. They don't want to buy a business and have a mass exodus out the door. So it's hard, and it's tough. Again, buying a business, it's not like buying a house or a car, an inanimate object. When you're buying a business, you're dealing with living, breathing people. So, but there are ways that it can be dealt with. And again, this is where making sure you have kind of advisors who are experienced and on your team, whether it's your accountants, your lawyers, just to kind of give you proper guidance and not just to barge ahead and say, I'm going to buy this business, but I don't want this staff, and you get off on the wrong foot.
Great, thanks,
Here's
Pat.
what I think I just heard, Pat. Yeah, I think what I just heard is we need you back to have another episode just to talk about that kind of stuff and those issues. So maybe we'll do that.
I'd be happy to do that.
I think one of the things that a lot of our clients miss is that in most of the businesses we're dealing with, the staff really are the goodwill. Mm-hmm. Right? It's all about the relationships that the staff have with the clientele of the business that is really what the goodwill is all about. And if they were gone, you're really paying for goodwill that you're now letting go out the door. So I think people miss that.
100%.
I'd like to shift gears. I'd like to shift gears for a bit here and go to a completely different topic that comes up in almost every pharmacy transaction we're dealing with, and that's leases and the assignment of a lease by a landlord from the seller to the new owner of the business, the buyer. Most pharmacy businesses are in leased premises, so they're not owned by the current owner. There are some exceptions to that, but the vast majority are in leased buildings. And so we run into a lot of issues around the assignment of the lease in terms of things like, is that a good time for the buyer to potentially negotiate new terms? Heather, you might want to weigh in on this too, from the perspective of what kind of length of time of security do you need, and if the lease doesn't have appropriate renewal options and those kind of things. So can you touch on a few of the important issues around lease assignments from seller to purchaser?
Or Heather, do you want to talk first about what the bank looks for in terms of term and security, and then I can chime in after that on some basic legal issues?
Sure, Pat. So the bank is always looking at the lease to ensure that the number of years in the term plus the renewals is the same amount at least as the amortization. So if we're offering 10 years amortization on a loan, we would want to see 10 years total, at least a minimum of 10 years in the lease terms and term and renewals. So that's one of the first things we're going to look at. We also would be looking to see if there's something like a demolition clause in there, various clauses that also might affect the buyer.
Okay, I'll jump in here. And if I can say, if anyone out there has a lease and they lease their business, it's so important, often overlooked. See if you can at least try to find and put together a complete set of lease documents. You'd be surprised. I would say on over half the deals we're working on, especially ones that are sort of coming in the door and refer to us, the clients have a hard time trying to find a complete set. That would be the original lease they signed, especially if it's going back 20, 15 years, and all the renewal and amending agreements. It's probably one of the most important pieces of the whole puzzle. And so try to find it. If you just signed a brand new lease, then that should be a piece of cake. But if you've been in your space for a while, find all those documents. They're very, very important because you want to be able to analyze. And it's something, if you're in the last of if you got 3 years left on a 5-year term and there's no renewals, well, if you think you're going to be selling in a couple of years, maybe you can go to the landlord now and try to negotiate some kind of renewal term. You never want to find yourself in a situation where you're in the last term without any renewals left. What I found over the last 10 or 15 years, and Phil, you may have found the same, landlords are very reluctant to give anything that they don't have to give. And it used to be that every time you'd renew, landlords would say, okay, we'll renew this one, we'll tack another 5 years on at the end. Now it's a little tougher to get that. But certainly the assignment clause is important. Dealing with the landlord early on in the process, if the parties are shooting towards a closing date, is very, very important. What I've learned is landlords just have a way of moving at their own speed. And if that speed is slow, there's really nothing you can do to get them to expedite things, especially if you're dealing with a big pension fund or a Cadillac Fairview or someone like that. So that process has to get going fairly early on. But in order for your advisors to advise you, make sure you get a complete set of your lease. If you have a demolition clause in there that Heather touched on, that's a clause that basically says, notwithstanding the term or any renewals, a landlord, if they want to redevelop on 12 months notice, they can basically terminate and kick you out. That could really affect the marketability of your business, because the buyer doesn't want to go in and risk being kicked out. From a buyer's perspective, if we come across those as part of the assignment process, we try to negotiate a freeze with the landlord. Sometimes they're open to that. That'll be a clause that says, okay, we won't exercise that for 5 years. We have no plans. But honestly, landlords now with buildings that aren't even out of the ground yet, in the leases, they're putting demolition clauses in. As crazy as it sounds, that they'll put it in there. They say they won't activate it for 10 years, but they're already building these things in. And it's funny when I think back when I started 25 years ago, we rarely came across these demolition clauses, but now we always are. And it kind of, a light bulb went off one day and they said, well, that's because all the buildings now, or most of them, are 25 years older. And as landlords go through and when they renew, and just again, getting back to the topic of what you might think is a simple, innocuous document, whether it's a letter of intent or NDA, anytime even a landlord tries to give you something to sign, even a renewal agreement, don't be afraid. It's so important to stick it under your lawyer's nose. I had a number of clients send me things when they were applying for the SECRA relief, that landlords would try to say, okay, I'll give you, I'll apply, but just sign this renewal now. And then the landlords are slipping in all kinds of demolition clauses and things. So you really have to be on your toes with these landlords. It can be pretty unscrupulous. But Phil, you hit it right. The lease is so important from a buyer's perspective and a seller's perspective. If it's a good lease, a 10-year term, say just signed with a 5-year renewal, generally not a problem. If you're dealing with only 2 years left and no renewals, but usually that's something that can be negotiated. landlords are in the business of wanting tenants in there, so they're going to be open, and sometimes a tenant will have a little bit more leverage than they think they do, but it's still important to treat that with the utmost importance on any deal. And again, look through your drawers and cupboards and see if you can find a complete set of lease documents, because if you're going to sell at some point, A, you're going to need it, and B, most importantly, this happens a couple times a year, know the deadline. If you have renewal options that you have to give notice, because if you miss that deadline by one day, it could really put you behind the eight ball. So if you don't know what your deadline is, make it a goal over the next week to look at your lease, figure out so that you know, because once or twice a year, I have clients call me, Pat, I'm supposed to give notice, I forgot, and now this, can you help me get out of this pickle we're now in? So,
yeah, Pat, as a follow-up question to that, Derek and I will run into clients who physically own the property or the strata, the building that their pharmacies exist in. Is it better for them to, if they're thinking of selling, to write a lease prior to them selling, if they want to remain in ownership of that property, that strata, as opposed to negotiating it after the fact? What's your thoughts on that? And maybe Heather, you can weigh in on this as well.
My thoughts would be that usually when you have a non-arm's length situation beforehand, the lease that's put in place is going to be not very friendly. So it's not one that's going to be suitable if you're getting now a buyer in. So it's an arm's length relationship. So clearly part of the sale, the first thing the buyer is going to say, can I see the lease? So as a seller, you don't want to give them the lease that maybe you've papered just for accounting and tax purposes. You want to talk to your lawyer and say, hey, I'm thinking of selling. Let's put in place a proper, reasonable lease that will provide for an arm's length relationship and the usual protections. And then the buyer's lawyer, they'll look at it, and if they think there's usually a little bit of back and forth still, but clearly that's something they want to have ready to go, the lease that they're ready to present to the buyer.
Any thoughts on that from your end, Heather?
I would say anything that you can do to work on something ahead of time is always a good thing. It's always easier to steer something that's already moving. But again, as Pat says, they would want to work that out together and customize it. And the bank is always concerned with the total number of years in the term and renewals. That's always the first thing I look at.
Great. So we're rapidly running out of time for this episode. So I'd like to maybe pose one last question. And I know there's some topics we didn't touch on, and we've jumped around a fair bit, but we really want to give our audience a sense of a lot of the different kind of legal components and aspects, and financing as well, aspects of doing these business deals with pharmacies. And so maybe, Pat, you could just give us, in sort of summary, a little perspective from your view with regards to the importance of having the right team of professionals that can work together. So that might be lawyer, accountant, pharmacy business advisors like Phil and I, bankers, that kind of thing. And what are your thoughts about how important that is?
No, it's extremely important, because for a lot of these pharmacists, they know pharmacy, but they're not, and they're experts at that. But usually, a lot of them may only buy one pharmacy or open one pharmacy in their life. Some people will go and get a couple more, but that's why to have an accountant who knows, tax and the tax implications of incorporation and buying and selling and how to structure yourself so when you sell, you can claim your capital gains exemption, extremely important. Having a banker, if you're a young pharmacist and you want to go out and buy, you want to make sure you have someone on your team who knows the pharmacy industry, who can explain to you what to look for. Because again, I know as part of Heather's view, they do fairly extensive due diligence, excuse me, on the actual business itself. A lawyer as well. Again, just having a group of advisors who have been involved in deals, and even there are particular elements even to buying and selling of a pharmacy that you don't see in other deals and provisions. So you want to make sure you have someone who's had some experience with pharmacy. And Phil, you and Derek, you guys know, I would think, more than anyone in the province in terms of just a general state of the market and what's going on out there. So to have, I can't stress enough how important it is. And again, get your advisors involved early on in the process as possible.
Great advice there, Pat. Thank you. Heather, any closing comments from your end?
I would say, as far as partners go, you should pick your partners carefully. It should be people who you feel comfortable with, who don't talk down to you, who can explain and guide. The way partners interact is very impactful. I think in the last episode, I had mentioned somebody who had they decided to go with somebody cheaper, and in their perception cheaper, and the lawyer went on holidays during the closing and left everybody hanging, and so that's why it's so vital to get people with experience, people like the panel here, who work together well, who can smooth over the things you don't see behind the scenes, the friction, the in the deals, the snags that come up, some hurdles, and your partners. If you get the right partners, then they can work together so that you can have a smooth experience, and at the end of the day, you can step into that pharmacy without worrying about the things that we have taken care of that you didn't know about. So that's what I would say. Don't always look for the cheapest option, but look for the best options.
Well, that's great advice from both of you. Closing comments from your perspective, Phil?
Great discussion today. I want to thank both of you for being with us, and we just encourage anybody listening to reach out to any of us on the panel here. If you're not sure what the contact is, you can contact Derek and I via rxownership.ca, and we can put you in touch with either Heather or Pat. I got lots of questions, Derek. I don't know about you, but we could probably do another episode on this, and maybe we'll look at that in the future based on the feedback we received from today's episode.
Yeah, I agree with you. There's a number of topics that we still didn't touch on, and so we may have to have Pat back and touch on some of those other topics to just provide a little bit more broader context. But great information today. Again, Heather and Pat, I echo Phil's comments and thanking you for your participation in today's episode. And Heather, thanks to BMO for sponsoring this episode. And we hope that our listeners have found it informative, and that the information is useful to them as they proceed with their pharmacy ownership aspirations or potential retirement aspirations if they're selling. So with that, we'll close out this episode of Pharmacy in Flux. Thanks for tuning in, and we'll catch you next time.